Many informed voters are probably familiar with Trump's absolute immunity from criminal prosecution claim that is now pending before the Supreme Court. Trump's attorney argued that the president could be immune from criminal prosecution even if he or she ordered the assassination of a rival or staging a coup. I doubt that the Republican justices will explicitly authorize that kind of result, but they do seem inclined to grant immunity for presidential crimes arguably related to official acts. Trump's idea is to convince the Republican justices to unleash him if he wins in November, with Trump arguing thereafter that he can do whatever he wants under Article 2 of the Constitution and cannot be held to any account other than impeachment. And there will never be enough Republican votes to impeach Trump, no matter what he does. That is his argument in a nutshell, and it is something that he has said many times that has been captured on tape, that Article 2 lets him do whatever he wants to do as president. A majority of Supreme Court justices today claim to be originalist or strongly lead toward originalism. See article titled, this quote, "The Supreme Court's originalists have taken over. Here's how they interpret the Constitution," and a quote published on September 25, 2023 at the Conversation website. All of the originalists are Republicans, of course. Prior to their appointment, originalism was regarded as a fringe movement by legal scholars. Originalists claim that they will interpret the Constitution based on how it would have been interpreted in the era when it was written. This judicial interpretation standard is clearly reactionary, grounding the meaning in 18th century ideas, and requires the justices to become historians. But the Republicans view that kind of judicial interpretation as anchoring the meaning in something concrete, and reactionary is their preferred personality trait and ideology anyways. So originalism is what they will do until it does not achieve the result that they want. The most recent example of ignoring what the framers intended will be the originalist creating a presidential immunity for criminal acts that are arguably related to the president's Article 2 powers under the Constitution. Those who participated in the writing of the Constitution and its ratification understood that the president was not above the law, said so many times, and could be prosecuted for criminal acts. Historians submitted an amicus brief to the Supreme Court on this topic. I suspect the Republicans will ignore it. The brief is available for viewing on the internet. This is a quote from that brief. Quote, "There is no evidence in the extensive historical record that any of the framers believed a former president should be immune from criminal prosecution. Such a concept would be inimical to the basic intentions, understandings, and experiences of the founding generation," end quote. Charles Pinckney of South Carolina, who was a delegate to the Constitutional Convention in Philadelphia, said outright that his colleagues did not intend for the president to have privileges or immunities. This is a quote from him. Quote, "No privilege of this kind was intended for your executive, nor any except that which I have mentioned for your legislature." See page 15 of the historian's brief. James Iredell, that's Iredell, one of the first justices on the United States Supreme Court, told the North Carolina ratifying convention that if a president, quote, "commits any misdemeanor in office, he is impeachable, removable from office, and incapacitated to hold any office or honor, trust, or profit," end quote. and if he commits any crime, quote, he is punishable by the laws of his country, and in capital cases may be deprived of his life. See pages 17 to 18 of the historian's brief. I would note that the framers specifically created an immunity for legislators in the speech and debate clause. Nothing similar can be found in the Constitution as written for the president. And nothing could be clearer than the founders did not want the president to be a king, above the law and unaccountable to it. Justice Kagan made this statement during the oral argument. Quote, the framers did not put an immunity clause into the Constitution. They knew how to. There were immunity clauses in state constitutions. They knew how to give legislative immunity. They didn't provide immunity to the president. And you know, not so surprising, they were reacting against a monarch who claimed to be above the law. End of quote. Compare that comment with the one made by Justice Alito when he suggested that a president might try to stay in power after losing an election if he or she believed that they would be prosecuted for crimes after leaving office, which just turns the whole Trump episode on its head. And it was necessary to protect democracy, in Alito's opinion, by granting the president immunity from criminal prosecution so that he would not commit crimes to stay in power. It is just obscene. It is important to recognize that the so-called conservatives on the Supreme Court will create constitutional provisions out of whole cloth that fit tightly within their ideological and religious beliefs or what they view as good policy. Creating an immunity from criminal prosecution for a president will be a first, something created in 2024 for Donald Trump that previously did not exist, and it cannot be justified or reconciled with the professed judicial standards used by the Republican justices, at least when those standards achieve the policy result that they want to occur. I have discussed that kind of issue in other contexts, and we'll link in the more section below one such discussion that relates to incorporating the Second Amendment into the Due Process Clause of the 14th Amendment that allowed the Republican judges then to strike down a state gun law. The main point I'm making here is that the Republican justices have somehow convinced people that they apply the law as written, that they are originalists, that they're textualists, and then they go about and create their own constitutional provisions to accomplish some policy objective that they consider to be important. In other words, exactly what they accuse the progressive and liberal justices of doing.